Good afternoon, everyone. It's a pleasure being here with professors which are of high rank. I would like to thank IBDT for being invited to be part of this forum. I've been working with them for many years. We are in the 8th section. It's a pleasure. It's a very important forum. It's the history of our tax law. And I thank Luís Flávio, Professor Luís Flávio Neto, and I extend my homage to the board of IBDT. The theme of our panel is international tax planning. I am Marcos Valadão and Professor Philip Baker. It's from London and Oxford universities, a visitor, and Professor Gustavo Neto, coordinator and professor of the Professional Master on International Tax Law and Development of IBDT. And the resume is being read. Professor Clara Moreira, moderator of this panel as well. Tax Law and Development at IBDT, Master and PhD by USP. Professor Isabel Garcia, Professor and Master, London Economic School, as a PhD. And my friend Ana Cláudia Utumi, professor at IBDT, master course, and Dr. PhD by USP. It's our panel. Forming this panel, they are experts in the subject of high rank with extensive knowledge on the theme we discuss. The themes, despite the title, is international tax law. We have, in case we can extend concerning international tax law and the subject of COVID-19, we will discuss the anti-evasion norms, and we also have the post-BEPS scenario with news concerning this. As we see, the BEPS clause, that's the purpose that is considered the main purpose. I'm sorry, it's more open than we have in other legislation internally, domestically, and we also deal with the subject which are concerning international tax planning and Brazilian tax planning with the administrative clauses, mainly when it refers to international tax treaties. That's the focus of our panel. And besides that, I would like to remind you that the themes discussed here are in articles or papers, and they are chapters of an iBook that will bring the subject of this seminar published later on. They will be accessed by the participants online. So we will have this material online in a very important forum with a lot of content. No further ado, I pass the floor to Clara Moreira, professor. Thank you, Marcos. Now I would like to pass the word for Philip Baker, because he will deal with the international and European tax planning treaty.
Very good. Can I begin? I hope that you can hear me. If you can't, please let me know. Can I begin by thanking the organizers for inviting me to speak today? And I've been asked to speak on international tax planning, but particularly in the context of state aid and the European Union. I should say there's a certain degree of irony here because, of course, I belong to a country that technically has left the European Union and where we're actually disputing with the European Union about what state aid rules we might have in the future. But I'm going to talk about European state aid rules. The state aid rules are based upon a relatively short provision in the Treaty on the Functioning of the European Union. It's part of the competition rules. They're not the tax rules. It's a very simple provision. Any aid granted by a member state or through state resources in any form whatsoever, which distorts or threatens to distort competition by favoring certain undertakings or the production of certain goods, shall, insofar as it affects trade between member states, be incompatible with the internal market. So it's a general prohibition of governments giving aid to particular companies or particular products which affects trade between member states. There's no doubt that this applies to tax. It was designed primarily to stop governments giving money to companies, but equally taking less money from companies, giving them tax benefits, can also be a form of aid. Where there is an alleged state aid, it's investigated by the European Commission, not the tax people, but the Directorate General that deals with competition, DG Comp. If they defined state aid against a government, then the government can challenge that before the General Court of the European Union, and ultimately the case can end up in the Court of Justice. Now, up until the late 1990s, there was very little interest in state aid and taxation. The main focus was on direct aid given by governments. But just at the end of December 1997, as part of the so-called tax package, the European Commission adopted a code of conduct for business taxation, which said that they would be applying state aid in the tax realm. And in the 2000s, I'm starting with a bit of the history here, in the 2000s, the state aid investigations focused on special tax regimes, where particular governments created a special regime for a particular type of company, and those regimes were being used as part of international tax planning. Things like the Belgian Coordination Center, the Luxembourg Coordination Center, special regimes very much linked to the OECD work at the time on harmful tax competitions. And frankly, as a result of the combined state aid investigations and OECD work, many of these regimes were closed down by the mid to late 2000s. Moving forward to the 2010s, the background here was a number of inquiries before the US Senate and before parliaments about so-called sweetheart deals for companies. It was realized that without creating a special regime, individual companies could be given a benefit by a ruling or an advanced pricing agreement. And in the early 2013, the OECD was starting its BEPS project, and the European Commission started a number of state aid investigations focusing on rulings given by governments to particular companies. We'll see which companies they were in a moment. It is very much linked and parallel with the OECD BEPS project, particularly Action 5. What were the companies that they investigated? You probably know all the names. The Commission published a decision on Fiat, who it was alleged had received state aid from Luxembourg in the form of a transfer pricing ruling, Starbucks, alleged aid from Netherlands, Apple, alleged aid from Ireland, Amazon, alleged aid from Luxembourg, Engie, the French energy company from Luxembourg, McDonald's, don't quite know what that company does, but alleged aid from Luxembourg, there something to do with buying Big Macs. That was the only case where the Commission in its investigation found no aid. In all the other cases, they found that the government concerned had given aid. Some of them are still ongoing. Amazon and Engie, we don't have a decision yet. Well, as I mentioned, the governments and the companies can challenge decisions, and that's what they did. And as you will know, we have a number of decisions of the General Court in this area. The only case that the European Commission has won so far is the Fiat case. In a decision in September last year, the General Court found that Luxembourg had given aid to Fiat. Fiat is challenging that and appealing that to the General Court. But on the same day, the court decided that in the case of Starbucks, no aid had been proven by the European Commission, and perhaps biggest headline of the middle of July, 15th of July, the General Court held that in the case of Ireland and Apple, the European Commission had failed to prove that Ireland had given any state aid to Apple. And we have until another week from now for the European Commission to decide whether they're going to appeal that case. I can't say any more about that because I'm actually involved in that case as part of Ireland's legal team. There are still two of those cases pending. Amazon, there was a hearing in March. NG, there was a hearing just 2 days ago. The current position is a rather strange one. The European Commission has generally won the cases on the law. Their propositions of law have generally been upheld, but they've lost them on the facts. On the facts of the case, the Commission has failed to prove that there was, in fact, aid given, for example, to Starbucks or to Apple. There's no doubt that so far as the law is concerned, the Commission has pushed the boundaries of state aid investigations, and they have now established their position that they can investigate rulings, particularly transfer pricing rulings, given to groups or companies which may be part of an overall international tax plan to reduce worldwide the taxation of that group. The state aid agenda is in a sense a background to another development that I want to highlight very briefly, and that is the Commission's recently announced fair and simple tax agenda. This is the European Commission takes office for 5 years. A new commission took office at the end of last year, and this was the publication of their agenda for the years up to 2024, 2025. It was published actually on the same day as the Apple decision. It's an interesting question as to how significant that was and whether the Commission was trying to, maybe the Commission had rather guessed that they were going to lose the Apple case. So they decided to try to divert attention by announcing this agenda. There's lots of things in this agenda. It's an action plan with 25 actions. There is also a proposal to extend the arrangements for administrative cooperation, the Directive on Administrative Cooperation, to extend to digital platforms. That's a proposal that digital platforms like Airbnb and Uber will have to provide details of the customers and the services they're provided to tax authorities. For third countries, including countries in Latin America, my own country now as we leave the European Union, there is a communication on tax good governance. That is, the European Union is going to take an international stance promoting fair taxation, clamping down on unfair tax competition, both in the EU and internationally. That'll involve, for example, an update to the EU list of non-cooperative jurisdictions. I'm certain nobody attending this conference lives in a non-cooperative jurisdiction. There will also be work with developing countries. There's a rather smart graphic there from the European Commission there. I can't go into detail into the simple tax agenda, but I just highlight some of the points about it: assistance in the recovery of unpaid taxes, withholding tax relief at source, perhaps on the positive side, a charter on taxpayers' rights, also some work on transfer pricing and standing committee for dispute resolution. It's a very ambitious plan intended to extend as far as 2023. And when you read an ambitious plan in the present moment, you ask yourselves, how well is it going to survive member states' concerns over COVID-19? With that little point, I'll leave that and pass back to the chair. Thank you very much indeed.
Muito obrigada, Philip, pela sua aula.
Presentation. It's a very good class. I think that we also have a lot to learn, and now new things will represent good challenges and the treatment given to the international tax planning. And now, before passing to the next lecturer or panelist, I'd like to launch the first question. The attendees, we have 30 seconds for Q&A. Is the principal purpose test PPT compatible with the principle of legal certainty? And to start the presentation about this theme, I invite Cláudia to start the debate. Professor Cláudia. Thank you, Clara. It's a pleasure to be here, principally with Mr. Philip Baker, professor, with the other persons that form this panel. And before anything else, I would like to say that Valadão did not pronounce my name correctly, but it's right. The way you pronounce it is the right to pronounce it. Valadão was totally right concerning my surname. And I'll share with you in order we talk a little bit about the theme I chose to talk about it today, GAR, G-A-A-R, and Principal Purpose Test. It is in the Brazilian scenario as well, and this subject is being discussed in several parts of the world. It's a discussion that is not exclusively Brazilian, it's not tranquil, easy to face. We're starting, we're crawling in this discussion concerning principal purpose test, and it will take long, certainly, to be in shallow waters. That's what you can see in my picture. It will take a long time to discuss and learn, and whilst there is a big concern for the taxpayers and the authorities. So, when we talk about economy in case of tax, the question that tax people listen are offices or as individuals that do works in the area, or the question is, can we go ahead with a transaction that will reduce taxation? What the taxpayer can do to pay less tax, you see, without having significant risks in case of dispute. So fundamentally, that's a question that it is in our daily lives, in the companies, in the decisions of the companies, in any operation that reduces the tax burden. See, it's a consequence, an effect, and we have to remember that in Brazil, we do not have a rule that is general. anti-evasion. So what we have here in the sole paragraph of Article 116, it's mentioned as a general rule in this case, when you have a judgment that is still in the federal court. We have the Carmen Luz as the reporter, and the paragraph. It is constitutional, and secondly, does not serve here the purpose of cases where you have elision, task elision. So you have the economy that is concerning taxation illicit. So according to Minister Carmen Lúcia, it is tax evasion. So it does not exist a normal rule in Brazil, but there is, as a consequence, many disputes and a meaningful value involved. And so the amount involved in the disputes in each of them easily can be billions. So it involves billions of reals, dispute of a sole company in this theme. Therefore, if I do not have the anti-evasion rule, as a general rule, which are the mechanisms that we use for importation of concepts, substances, and analysis purposes that we're going to talk now concerning simulation. And frequently what we see over the last 10 years, the concept of abuse of law in a sense that is very broad abuse. And so every time I have a simulation, a sham or abuse, I have a taxation, and the situation is considered like tax evasion. So in this case, it involves, for instance, being against, acting, performing against the considered the right objective in terms of law. The purpose, the economic purpose of that legislation. It's a very broad concept. So we do not have a very clear legislation about the concepts of purposes, business purpose and substance analysis. So in many cases, we find situations where the analysis of the business purpose, I would say it is like an engineer that has the work already done, arriving in a building and saying, we should have more windows. The door won't be here, should be at the other side. So that's the engineer that in case of any litigation, any dispute, people do not understand the economic reasons that took to that situation or that decision. So saying, yeah, but if I were the taxpayer, I would never do 5 windows, I would do 4. If I'm the taxpayer, I would never put the door in the middle of the wall. So, of course, there is a distortion in the analysis of the purpose, because we have situations sometimes that clearly you have a series of business purposes that can be analyzed according to many minority agencies. There are many economic reasons. It takes to disputes exactly because the understanding is that taxation economy would be understood as not correct, incorrect. So the principal purpose test that is in the scope of BEPS work included in the Multilateral Convention on Treaty Interpretation, MLI, it was included as part of prevention of treaty abuse. And in this sense, prevention of the abuse in the treaty What is brought in MLI? It brings the benefits under the covered tax agreement shall not be granted. When you analyze all the facts and circumstances, you can reasonably conclude that that benefit of the treaty was one of the purposes, main purposes, more important purposes of that transaction that is being analyzed. And therefore, we also have to see and understand that you have to analyze, taking into consideration the total of what has been done, the set. So is it clear that the benefit of that treaty is relevant enough to be considered one of the main countries, when the main purpose, principal purpose, the sole principal purpose is save concerning taxation. So we have many experiences about it. And from the point of view of Brazil, although we do not have legislation about this discussion, substance, it's clear for us that the operations done with one single purpose of to save in terms of taxation, in these operations, the result will be in a litigious situation, even without a legislation that is clear. That's the result presented. The purpose is not to save in terms of taxation, but the taxation economy is important. So here, I consider that I have Brazilian stroke Netherlands treaty, a discussion about royalties. And when it refers to Spain, it's royalties of 10%. So I transfer all the management of the intangibles from Holland to Spain because it's lower. Can it be considered concerning the PVT test, something that would be bad? May I explain? Okay, I came to that stage because that's the only objective. It's saving 5%, for instance. If I am just closing the doors in Holland, because in Spain I'm centralizing my operations on Europe there. So in that case, several economic reasons. So I'm showing that I have reasons that are economic reasons to support. So if in this administration I'm doing, the taxation economy represents 3% of the saving, total saving of the project. So if it is 10% or 15%, how do we identify? So the principal purpose. What's the principal purpose here? To what extent the purpose becomes one of the main purposes or principal purposes? If it's 3%, it may be too little, or 8%, it will be more relevant, 10, and so on. So when it refers to treaty, but a big concern that we do have is exactly analyzing the PPT and having influence on the analysis, the taxation analysis, even in the absence of treaties. It is expressed in the MLI, in the interpretation of the treaties of the signatories of the MLI, not including Brazil. Brazil is negotiating, and it's not a signatory yet of the MLI. So, but the principal purpose should influence here. So do I have business reasons enough? Do I have the carve-out that is considered a judicial cause, a legal cause? Even then, it's irrelevant, the saving. So how can the principal purpose affect here? I have a situation where the taxpayer free to do and use several concepts in discussion. This concept, the morality, because they have the moral purpose of paying. So the objective in terms of business payment in a fair way, the taxation. I don't know the limit. In Brazilian case, I don't know what's the limit. If you ask and you consider a transaction and ask the opinion to two taxation experts, you have three opinions because everything can be discussed and questioned. You don't have clearly this definition. And I believe that this definition should come via general norm, general rule, anti-evasion, not only the case of interpretation, the very broad of the civil code. In fact, the GAAR does not do miracles. We know that this new measure does not do miracles, does not solve every problem. But GAR will help and would be useful as a guide for the taxpayers and authorities in general concerning this subject. And it's important, as Brazil does not have a GAR, so and the anti-vision norm or rule would bring these new concepts that are internationally discussed. So just to complement the last point of the slide, GAR may not solve all the problems. At least GAR can bring some light, shade light on the disputes between taxpayers and the authorities. Because nowadays we are having a situation, we have so many concepts being discussed. Any dispute that between the taxpayer and the excise, there are many reasons, different ones. Internationally, we see this, what can be accepted or not, and to add to the purpose, the principal purpose discussion, we do have the discussion going on. So in fact, we need a guideline, a master guideline, even if it's not the solution of all the problems. Therefore, I defend, okay, we have to have a general rule in terms of anti-evasion. So favorable, not favorable, but it has to be discussed in the present Brazilian scenario. It will be much better than simply adopt the broad concepts in the civil code. So with that, I thank you for the opportunity to be here, and I pass the floor back to the moderator.
Thank you, Ana Cláudia, and for your remarks to start a debate that will be followed by Professor Luís Flávio. Luís Flávio, IBDT, how is the relation and the possibility of the seed of communication amongst these rules and standards? Thank you, Clara. Well, I cannot congratulate each one of you, Marcos, Aurélio, Valadão, my dear friend, Professor Philip, who asked us not to call him professor, just Philip Baker, but it's an instinct of calling him professor, the one who taught me international tax law for so long, so many years, for his books, presentations, and work so it's instinctive, but I will try not to call professor. So thank you, Philip, for being today with us.
Clara.
And Utumi, it's a huge pleasure to be here. This week has been one of huge academic pride. Sunday, Monday, Tuesday, the first seminar of researchers of international tax law fostered jointly by IBDT, IBFD of Holland, and the Largo São Francisco University. We received 32 researchers from 15 different countries doing their dissertations of PhD, post-PhD. Now have the Congress yesterday, today, tomorrow. We have the e-book Valadão mentioned. I received the message that some of you did not receive the e-book email. So we are asking the technical team to resubmit the e-book to the email and with the work of several panelists. So many subjects, so interesting being addressed. So I'm so happy of being here today. And the subject also is a fantastic one, the one that was asked me to just talk international tax planning. And so it's not new. It's something that follows us for a very long time. I would say if we analyze works by Professor Klaus Flober, we have several points and food for thought, including the understanding that there would be implicit on double taxation agreements a clause anti-abuse. In spite of not having a clause expressed on double taxation agreement, there would be a international way of doing things that would justify implicit fight in double taxation agreements against abuse. We have a no debate even in how internal standards of countries could be addressed when we talk about international tax law. Professor Ana Cláudia advocate with Magaia of Brazil, what shows that in the opinion there would be the relevance of Magar of domestic law for dealing with tax planning within the double taxation agreements. It's something old and it's there for a long time. And we have some new things also, naturally. The world post BEPS brought several issues to be debated. So today, briefly, I will talk about the how I see the Brazilian scenario, how I see as of the enforcement of double taxation agreement celebrated by Brazil, and I see the enforcement of these debates regarding the international tax planning, especially regarding in this first time I'm here today in this event. So once I would like to honor Philip Baker, Professor Philip Baker. I was researcher by IBDT in '08 approximately, and Professor Francisco Bianco, who was the chairman of the first panel of today of this Congress, asked me to write an article on treaty shopping, and I wrote about it. And today, at that time, we printed, and I gave to João Francisco Bianco, and he got the text before reading, looked at me and said, "Did you go to the Philip Baker book?" And I did my homework, and soon I learned without, you don't study Philip international tax law before reading your books, professor. So thank you very much. I had to say this. Well, we have some debates that have moved forward regarding the subject matter during the last years. I remember the beginning of '08, one of the IBDT congresses, one of the international lectures that we have today in this congress were back then also. And they said in '08, our source countries, they are moving towards reacting the international tax planning due to the need of resources brought by the crisis that started to affect the world at that time. In Brazil also there was, I heard the governor saying that it would be a small wave, not a big wave, the crisis, but later on it reached the Brazil, and it was a huge tsunami. So they were present in some countries. So we must react to tax planning. This is a different subject that Philip brought us when Philip talks about the state aid. He's talking how a court will limit the right of states to grant benefits and then foster uh, tax planning to make possible tax planning. Now, how states have the competence in order that they can react to tax planning, and then the project BEPS is a sharp change in this. We look the preamble of the model of the OECD pre 017 and the current preamble after the multilateral agreement, and incorporating here these ideas of intolerance to certain international tax planning, especially structures like treaty shopping, hybrid instruments. We have this message since the preamble of the new OECD MC. And so just a small bracket. What would be this treaty shopping? Translators, I don't know if they are translating this, there's treaty shopping, but when I translate it literally, is buying the right to a treaty. So in this slide here, I have the next state, Y state, Z state. Let's suppose that the X state does not have a treaty with Z state, but the X state has with double taxations with state Y, and Y state has an agreement with state Z. Therefore, if the company X co X co uh, conducts a transaction with Y company, we will have a treaty being enforced in an immediate way. But if I have an amendment to do in the wide thing state, I can have a jumping board and then I would have the access to the benefits of treaties. So basic structure of treaty shopping that case by case demands its own peculiarity. Just a bracket to talk a bit about what we are dealing with. Now, when the model convention guaranteed in its new preamble this intention of bringing general rules and more specific rules, also of specific rules for international tax planning, it's a message reflected in many others articles of the OECD Model Convention. We have the Article 7, 10, 11, all bringing these clauses that Professor Ana Cláudia Utumi addressed regarding PPT clauses. And then Article 29, a specific one that was added, dealing in a specific way, to say so, regarding the limit to the access of benefits from the treaty. In which situations the benefits of a treaty could be denied. I always think important when one deals with international tax law, naturally we talk about the OECD model convention, but we must look specific treaties also celebrated or executed by countries. The OECD figure can be compared to the National Health Organization. Who wouldn't like to have OMS and World Health Organization to conduct tests and saying all the countries have to behave in such and such a way to exit this situation like the World Health Organization. All would like this, but I think we all have noticed that it's no use just the WHO to recommend things. Probably many of us, we have to beg your governors to adopt the recommendations by the WHO. And each state is in charge of enforcing the recommendations. And so each state and all likewise with OECD, they also have recommendations. It can be bilateral, multilateral agreements. OECD have recommendations also for the domestic system. But when I say someone advocating some, say, holding the OECD guidelines, I always think it might be hidden in the tax code. So it's important to see the concrete case, and this is what I would like to address here and heading towards the end of my presentation. So what is Brazil in all that we're talking? It's a country without GAR. We don't have a general rule for intolerance of tax planning. This has been advocated for a long time. And the STF or Gene 2446, or already mentioned by Ana Cláudia, has headed towards to the understanding that we don't have a GAR, we just react against simulated transactions. Brazil reacts against fraud in tax matter. That's it. Simultaneously, we have 35, approximately 35 double taxation agreements where Brazil is a signatory. The recent one, like Argentina, Israel, Mexico, Russia, Turkey, Venezuela, and Switzerland, not yet in force. Argentina, we negotiated the treaty. Brazil did not sign the alignments. We are negotiating treaties, incorporating some of the ideas. These new treaties, they follow this new OECD standard, the preamble, there's the idea of preventing treaty shopping transactions, and also dealing with the clauses of PPTT. But then I would like to talk about the scenario of a biggest scenario. So consider the following scenario: pre-PEPS tax treaty. Of course, Brazil has some treaties executed with provisions, specific provisions limiting the access to benefits in certain cases. But this became bigger after BEPS. Let's think about those pre-BEPS treaty, 70s. No PPT clause. In a situation where the conduit company is no longer paper company. It exists and do conduct transaction. It's not just PO box. It's no fraud. It exists. And then I will give you a situation with two different scenarios. Let's say it exists to transact just to make use of the treaty, okay. But as an Cláudia showed us, the reasons with a different scenario, non-tax. So perhaps it's a region strategically important due to logistics. So we incorporate a company over there. And for a country that does not have GAR, how to deal with this? And then I'll just note I don't see, and I have the pleasure of publishing the ebook of the Congress, Roberto Codonizzi. We advocated the idea that there's no relation of necessary dependence between a PPT GAR. I can have a country without GAR executing agreements with PPT, not necessary either to have convergence between GAR and PPT. GAR might can be more restrictive than PPT and vice versa, though convergence needed. But I cannot deny there is a country with a better experience in enforcing its own GAR and the mistakes and its mistakes with the enforcement of PPT. This is the scenario we have today in Brazil. This is my reading, at least regarding most of the treaties executed before BEPS. And so, as Philip Baker, I'm concerned regarding saying that he would not address some cases that he's working on. I don't on. I don't like to address those cases I'm working on. Myself and Dr. Valadão are chairman today. We have attended that. We were advisors of Garcia together. I never mentioned one case I was help judging, but I'm no longer advisor. It's a well-known case, the rule case Eagle. So this is a case Eagle. It's the ruling was published. We know it as this name. It portrays very well and perhaps there's the risk of negative influence in the enforcement of theories of intolerance for domestic tax planning when it's dealing with international situation. This is a case judged in administrative sphere of Brazil, although we don't have the AGA, we have a jurisprudence administrative, which is quite controversial, and the judiciary, but not much about it, but these decisions affecting the GAF judgment or ruling. So it's not possible to say we have a case law that might be a guideline for the matter. In this case, it's very influenced the course of highly influenced that it reflected in spread premium based in some paying taxes, the principles of jointly, and so influence it was understood that in a situation where I have in Brazil Eagle Company, Uruguay, it's established a subsidiary in Uruguay and one company in Spain, whereupon the Brazilian company controls the Spanish company and the Spanish company controls the Uruguayan company. Rules of Brazil should be enforced, yes, CFC, so Brazil would reach the profits ascertained by the Uruguayan company, but do for the assistance of the Spanish company, because not exactly a company, it would be in thesis conduit company with subject matter of only allowing the access to the benefits of Brazil-Spain treaty once Brazil did not have treaties with Uruguay. This is the scenario. Curious also the scenario, the Spanish company had activities, own resources, that it paid taxes in Spain. So Brazilian court posed the question to Spain, and Spain answered practically, yes, this is a company, they collect taxes in Spain. So I don't want to delay, just want to show my stand on this. If you're curious to know more, I gave my vote in this case. I see a situation like this as one that's legitimate, where we could not disconsider the existence of this company in Spain. The benefits of the treaty should be granted. Yes, the existing relations of these companies, and perhaps I would perhaps the benefits of the treaty would override in. Besides these important points of state aid that Professor Baker showed us, the limits of states to flourish the intuit of tax planning of companies, I bring this point saying that what would be the limits of states in this considering tax planning against the existence of the rules in the treaty, and also regarding a domestic treaty that render support to this with this food for thought. I pass the floor to Professor Clara.
Thank you, Luís Flávio, for the explanation and the results of our quiz, please. Is the principal purpose test compatible with the principle of legal certainty? What's the result? Yes, 51%. No. So concerning the planning, tax planning, international tax planning subject, now the word is given to Mr. Marcos Valadão.
Ok. Obrigado, Clara. Antes
Thank you, Clara. Before starting my presentation concerning the case of international tax planning involving the CFC norms or rules, I want to place a comment here very briefly about GAAR anti-abuse, specifically when it refers to PPT. I do not agree in some points with what Professor Luís Flávio, it's a classic discussion between us, has mentioned in Brazil. We do the tax planning when there is fraud only. No, we have many cases where the negotiable things are perfect, and from the point of view that I have, but they are put aside because they contain abuse. It's not legal. It's not in case of order, but we do not have a regulated general rule concerning anti-abuse. In that specific case of vehicle, the decision, the state and we had different votes. It's a classic thing, not everything, but most of them. And I understand that there was there an abuse of the treaty with certain contours, and the decision concerning that was placed that way. So the question is, the treaties do not have, when they do not have a written regulation in the treaty concerning abuse, it's construed to establish disciplines for both countries. If you contour the relationship and you put a third country in the scenario, and so it can be set aside in case of the third state does not agree or the other state does not agree. The taxpayer there, if it's understood this way, it will be with the solution of controversies. So it can be used the map because that's also another way of solving it. I just want to put that. That's my opinion about it. We're going so quickly. So I will pass now to my presentation. But we will discuss GARD at the end, because it's so important. It has to be a collective discussion. So I'll talk about the Brazilian CFC rules, if the treaties apply or not. That's a present and important discussion, and I'll do a historical perspective. And I'll try to use my 15 minutes. I use part of it commenting about the issue of the anti-evasion regulation PPT, they exist or not. Brazil, it's important to deal here because there are many colleagues in the audience from other countries and they do not know our law, Brazilian reality in this aspect. So it's important to do the context quickly. What happens here until 95? Or 96, we did not have universally based about it. At that time, there was a movement, so 9249 law, introduced in the worldwide income taxation. So using the example, the incidence of income tax, and it was implemented in the beginning, but it was only ruled when there was a division of dividends. In 2001, we started problems. So the national tax code got modified by CEL, and the scope changed completely in aspects, temporal aspects. So the taxation, say after having the profit, the net profit concerned, we would have, I won't discuss the method of this type of taxation. It's another point to be discussed. So that's the law. And would it be constitutional or not? That was the question. It was taken to high courts in 2001, and the decision was presented a long time afterwards, in 2013, and the high courts understood and ruled in terms of approach the existence of operations in tax haven, because in this context, historically, it is to avoid abuse. And so the Supreme Court decided and ruled very complexly, and so observing the constitutionality and the taxation this way with controlled companies in tax haven, and it's not constitutional. Sorry. controlled campus or subsidiaries and collegated, i.e., they have the jurisdiction in regions which are not considered tax haven. So it's exactly what we want to say concerning sub-companies. And so in situation of controlled companies or sub-companies localized or situated in non-tax haven countries or sub-companies in tax haven, the decision is not precise as we understand that the rule per se as a principle we use and apply as a constitutional one. And in this decision, we have the new legislation that is the 2973 that in the past it was MP 2007 and it's transformed in 2014. And the new rules are according to the scope of the high courts. So the rule, CEPC, would not have the same standards, but in some themes, we see that they are very important. The interaction, possible interactions of the treaties and the CFC. Just to consolidate the present state, we have 2 points that are important to be discussed. Constitutionality of the law of the sub-companies, concerning the sub-companies that are not in tax haven, and if the Article 7 and 10 of the conventions would interact concerning the CFC rule, what would they affect the application? And so besides that, we have the BEPS project that deals some discussions concerning the scope of the CFC that would go farther the simple previous scope, classic one, of the anti-evasion specific regulation. This new view that would be a new type of CFC, how could it be? You see, there was some modeling to what Brazil adopted concerning 2973. So even then not very effectively in a passive or negative way. Okay, we will discuss these questions about payment deferral. It was another taxation in the distribution of sub-companies, as we've seen, according to the judgment of the high courts. How is it? The principal point of our discussion here, the interaction between the rule CFC and the cases decided in the high courts in the administrative trial. What was very important, it was the one Vale case, and in 2014, it's a Brazilian company that had sub-companies, and the decision of the court that there was the application of the law. So we went to the Article 74 in this case, and the decision that it was ruled that the Article 7 would apply and would put aside. I'll go back to this subject, but it was based on the 7 article that would put aside the appliance of the new Brazilian rule, or Article 98, of course, always applies because it's under the internal or domestic legislation. So it was based on OECD comments. Then you have the discussion if it's the new concept of the CFC rule. It's been discussed. So CARF, it's a decision. It's very important in case of Petrobras in 2016. And the company had a sub-company in Holland, and there is a Brazilian treaty with Holland, Netherlands, and CARF understood that the Article 7 or 10s, in this case concerning the dividends aspect, and the norm, the rule CFC, the decision that was taken at that time, our colleague in the panel, Luís Flávio, was there at that time. I believe that was the winner vote, not the winner vote, but with quality. In this case, it was understood differently from the High Court. There wouldn't be any setting aside according to Article 7 of the CFC Brazilian rule. So in a summarized way, the court recently understood and ruled that that it sets aside CARF understand that no, it should not be this way. And another argument, pros and cons. There is a list there on the screen, the evaluation, the assessment. And one of the points that is considered very important, Brazilian legislation taxes the gain as accrued by the Brazilian parent company in regards to the controlled company, not directly the controlled company profit, because so it's anti-abuse. So a Brazilian, the position of the winner concerning CART is that Brazilian legislation considers that the adding or increase of the equity, there is no taxation to the subcos in this case, in another country, but in terms of equity, this profit is taxed. And the Brazilian regulation would have to be according to the Action 3 of BEPS with a broader scope. And these points were placed, and these are the main ones, pros and cons. Concerning the judicial aspect, of course, it does not change the interpretation or what's been construed in the administration court, but the fact is that pandemic situation bringing problems, cash flow problems, or structural deficit, which are significant, it will impact the judicial decision or the legal decision. We call it hermeneutics. And yes or not, but it can be brought to subject when we decide this theme, specifically in the High Court and so the Supreme Court. Let's see if the situation, this difficult economic financial situation now will take to this decision in the High Courts. Now, let's see the hub of the discussion. Concerning the treaties, how do they affect the CFC Brazilian rule? The sub-company abroad, bringing the profit to be taxed in Brazil? How does it stay if you consider the treaties? It's important to note that the treaties do not have a treatment that's uniform concerning the subject. We have treaties that are totally silent concerning silence concerning this theme. And we see others that say that the CFC zone is not involved. And in case of wording, there are some treaties that say that they do not affect the CFC, but there are others that say yes. So you have 4 variations of the same theme. Please, let's. Okay, about to finish. So we have 4 alternatives. 4 alternatives. Treaties that have clauses, that have no clauses, treaties that have Venezuela and Russia, for instance. Clearly, it says that CFC rule is not affected by the treaty, and we have others like the Czecho, Norwegian, Slovakian Republic. According to the clauses, they say that the non-apported profits will not be taxed. So in this treaty, clearly we see that it affects the use of the CFC. So CFC will not apply in this case because there is an express condition to apply concerning attribution of taxation on non-assorted profits. And so in this case, it's not the case. And the fourth type is, it has a different interpretation that you can use the Brazilian CFC or not, depending on how you do the interpretation. If the rules apply to dividends, this are already assorted, or it's an anticipation of this distribution or a portion. With Austria, Spain, and India, you have clauses of this type. So they have restriction, variation. In the case of Austria, it will apply if the Brazilian participation there is 25%. So the dividends will not be taxed. Okay, when they are assorted, but they are there. They show the equity of the company, of the sub-company there. So it has affected the CFC rule. It's a discussion. When it's assorted, is it exempt? It's above 25%. So it's a discussion that I know that has not been decided yet doing the interpretation of this clause specifically for a certain case. In the case of Spain, it's been put aside because abuse of tax planning, so we cannot discuss it. So it's a theme that's still open, the theme is still open. And the fourth form of this rule, when you see if the appliance is done or not, the situation that we can conclude is what's the wording of the treaty and what's the wording of the applying of the treaty concerning profits and shared profits. Thank you, Marcos. Now I pass the word to Luís Flávio.
1 minute, just 30 seconds, because I would like to hear more Philip and Isabel also. Just a small remark. I think an event like this we could not disregard is Marcos brought us a very important case to be studied, Petrobras. I recommend you all to study it. It's a historical case. The last oral that it was done by Professor Xavier on the doctrine areas international tax law, and he's deceased. Important, this is a change in administrative case law, where I have the national office recognizing the treaty being enforced on the 10th article regarding dividends distribution, that this is the prosecutor's office while the taxpayer was complaining the enforcement Article 7, saying that it would be profits taxation ascertained abroad. The administrative court, most of it, I don't know, ruled that the treaty would not be enforced because taxation would be in a Brazilian company. So it was just a mere reflex of profits ascertained by the foreign company resident in the state where Brazil has a treaty executed. So it's very interesting, the case. Last, we had in a discipline the master's course in the first semester, and I taught together with Professor Schuere a discipline regards CFC rules. And due to the pandemic, this course was all online. And each year we brought a foreign professor and guest, and always we presented the CFC rule. Professor from abroad was amazed, saying, "It's different, your rules from ours." So we reached the conclusion that we cannot call here CFC Brazilian rules, in fact. So OECD, so it's an anti-abusive rules and pent up of passive rules. So in Brazil, we don't have this differentiation. It does not react against the abuse, but it tax immediately all unalien profits ascertained abroad. So Marcos clearly showed us, and I'm sorry I had some interruptions in his presentation. So this is what I wanted to say. Now we pass the floor to Philip. Please, you take the floor.
I just wanted to make two very brief comments about CFCs. The first comment is that we have a case in the UK, rather like the Eagle case of the relationship with the tax treaty, a case called Brycom, but we reasoned it differently in the Court of Appeal. They looked at the UK domestic legislation and concluded that the CFC law was not taxing the same income as the treaty applied to. The treaty applied to the income of a Singapore subsidiary. The UK legislation taxed a notional amount computed by reference to that income. So there was no conflict with the treaty. The second point I wanted to mention is, believe it or not, we have a case at the moment on CFC and state aid. The link with my earlier talk. The UK amended its CFC legislation in 2013, and the European Commission said, we made the legislation too easy to avoid. It has gaps in it, and because we don't apply the anti-avoidance legislation to certain income, particularly the income of finance subsidiaries, therefore we have given state aid. It's a very interesting concept that by narrowing an anti-avoidance rule, you can allow companies to engage in international tax avoidance, and that is state aid. I won't say anything more because I'm representing the UK government in the case, but I just wanted to mention that. Thank you.
Muito obrigada, Philip. Como minha última palavra, eu queria agradecer a organização.
Philip, I would like to thank the organizers of this event, and I pass the floor directly to Professor Isabel. Thank you very much. Thank you, Clara. Thank you all. It is a pleasure to be this afternoon with all of you, in spite of not being present, but thank you, Flávio, Professor Schuere, for the invitation and to attend this panel with tax counselors that I admire so much. Due to time constraints, I will be very straightforward in my presentation and that I will be sharing with you. And I think that the timing, the order could not be best planned, because I will show you a bit what we addressed regarding what is being tolerated as tax planning in Brazil and what our administrative court has this considered. And to illustrate this debate, the case of indirect sales of partnership stake. Before ingressing in those cases per se, in purpose, I have one case that the excise, one in the sense that it did not consider the indirect sale and treated as a direct sale, and the other case where the excise allowed the planning made by the taxpayer, even reducing the tax burden of the transaction, was accepted by the administrative court. And before ingressing in the first case, I will also do a brief explanation regarding taxation of indirect sale of partnership stake according to Brazil's legislation by non-residents. Article 26 of 10833 sets forth acquiring party, corporation individuals resident in the country, or even proxy when the buyer is not resident. So it's representing a non-resident. It's accountable for collecting and paying income tax on capital gains of the transfer, which is a non-resident when it is being done the sale of an asset that's located in Brazil. Therefore, it's important to stress asset located in Brazil because these are the law wording. Looking at Article 26, I have no doubt that Brazil does not tax indirect sales of partnership stakes. So capital gain of non-resident is taxed. So even if it's done by a non-resident, when the asset involved in this transaction is one located in Brazil. So this is the landscape of the legislation that we have in law governing this scenario. And then one can see the diagram. It represents the first case, which is COSA acquired ESSO. So the original structure of this partnership was I had two holders in the Netherlands and controlled by another company, and both companies controlled the target company in Brazil. And this target company and the accountant was Brazilian, had interest in acquiring the Brazilian asset. But when we structured this transaction, the selling party, the seller, was not interested of selling the Netherlands holdings. So it was negotiated and it was structured in the buy and sell contract that the acquiring party of Brazil, the buyer, Green, would acquire the new partnerships that were being incorporated in Netherlands, and these new partnerships would be the subject matter of acquisition by the Brazilian acquirer. Why this would be done as such? So the buyer, Brazilian, would acquire assets abroad and not assets located in Brazil in order not to pay taxes in Brazil. And this case was subject matter of fines by the excise, and it's important to say what were the arguments that prevailed the decision by the administrative court that this tax planning was not accepted, and in fact we were selling an asset in Brazil. The first thing we noticed were the buy and sell documents on the SPA and what was the subject of this transaction. All clauses mentioned the target company, the objective Brazilian asset, not the partnerships, new ones incorporated in the Netherlands. In addition to this, at the time, the SPA was executed according to the ruling by the Supreme Court. The A and B companies, new A, new B, were not yet incorporated. They were if 3 months of existence between being liquidated and incorporated, because after the selling was made, they were liquidated. So this was another argument that was mentioned and analyzed within the ruling by the Supreme Court. Another point that is interesting to mention is that all this was done to avoid withholding taxes at the source. So the excise understood that the remittance of value was a net one. So when it was disconsidered, the transaction saying is what is being sold is the Brazilian asset and the income tax was withheld at source, it was a gross up of the value. So the responsible for the collection had to collect a value even higher of taxes due. And there was some more debate regarding value of investment for the settlement of the asset, but the focus is not there. The issue here is it was noticed in this case that when I have scenarios that ephemeral, which are preordinated, that aim towards, in a way, changing what truly the taxpayer wants, the Brazilian taxpayer wants to buy the Brazilian company. That was the aim. This was disconsidered, so it was taxed. Indirect sales as direct it was. So in fact, according to my point of view, in what it was listed by the ruling by the Supreme Court, it was a direct sale with taxes withheld at source. On the other hand, we have another scenario, another ruling by the Supreme Court regarding the sale of partnership of indirect sales of a stake, where I have a partnership structure, pre-transaction, highly complex. You can see here the diagram. So we have to focus here. Brazilian company was controlled by three other companies of Brazil, in addition to a foreign one located in Cayman. Therefore, if I have a structure, this structure would make me have the selling by made by three Brazilian companies and one abroad. So I have 100% being sold of the target company in Brazil. But also, it was negotiated, and in the moment it was sold, we had a reorganization of the partnership. What was the outcome of the societário partnership reorganization? The control of the Brazilian company that was the subject matter of this transaction was handed to one Netherlands company located abroad, in addition to have a holding, two in Brazil. Holding, if you look at the diagram, the holding 1 and 3, they were incorporated. They disappeared from this diagram. So in the final diagram, I have the transaction made being, I will have a Netherlands company by a Brazilian one, and by the end will control the subject matter company of Brazil. And who was the selling party? The seller was the new Netherlands company. So in this case, different from the previous one, there was a tax withheld at the source and also taxation at the selling transaction. So why it was fine? Because Brazil's excise alleged that this selling, in fact, should be done by the Brazilian companies that before were the controlling companies of the company subject matter of this transaction. And why? Because when I have the selling of partnerships, I ascertain gains with a 34% instead of when non-resident sold in the tax haven is 15 to 22.5%. it goes in the line that Utumi plays so well. And safety, how much reducing the tax burden will generate a risk for taxpayers once we don't have a GAR. And in both cases, one can see that in the first one, according to facts description, there was an abuse by taxpayer and disconsideration. In the second case, there was a reorganization of, and in the report of facts that led the ruling to be favored to the taxpayer was noticed also the partnership of the seller, the reorganization that was proposed. Pre-sale was implemented in many other emerging countries, so the selling group was leaving the position in other emerging countries, and this was not something for that moment to reduce tax burden. But for Brazil case, there was a reduction of tax burden, but it did not zero taxes to be paid. Taxes were levied and paid. And what we notice with the ruling, very interesting, that they go there and say the simple reduction of burden without evidencing that there was a abusive tax planning on the artificial structure is not enough to have a consideration of the partnership reorganization, the structure used by the taxpayer. So one can see that we have those scenarios in Brazil today, and taxpayers are unsure up to when the planning will be accepted and up to when it will not be accepted. And following this line of thought of what we talked up to now, what do we have regarding indirect sales? Today, our law does not levy taxes indirect sales, just a direct sale of assets located in Brazil by non-resident. Brazil wants to change this rule. Yes, does it make sense to change this? Would it bring more be more safe? So how to change it? We would like to define, we will have to define what is Brazilian asset and the new tax and rules for indirect sales, if we are going to place this in the COVID scenario, how much this could influence the flow of investments, direct investments in our country, which is also an issue to be weighted. Let's implement, we can see based on international experience, we have the toolkit elaborated by the International Monetary Fund with the G20 and interest in developing countries that have a concern regarding indirect sales being made by big companies related to the tap of natural resources of emerging countries, how to regulate this situation. And then we could have different models. We have those countries that they waived and said, we're not going to tax that indirect sales. We have countries like China. Any handling of control is submitted to the tax authorities of China and other countries that mix the well-defined rules to say what is indirect sales taxation. So these rules should only exist and make sense if we could limit very well nexus of capital gain or by non-residents, cumulative of Brazil. Nexus between capital gain and source country is the key for well worded and drafted legislation. In this sense, it would be worthwhile with this well-defined rule to have a specific one anti-elision, against elision, and also to use this as a strategy. So I place for you these issues so we could reflect and thank a lot the opportunity of spending this afternoon with all of you. Thank you very much. Marcos, now we're going, Marcos, let's wrap up this panel. Thank you very much, Clara. I would like to thank all the panelists, Prof. Felipe Baker from UK, Ana Cláudia, Luís Flávio, Isabel, brilliant addressing of indirect transfer. Unfortunately, we don't have time to drill further in this, but it shows we have to think about it. And Clara, thank you for the coordination and to coordinate our panel, Clara. Thank you very much. Now, if anyone would like to do a final remark, so thank you very much. Philip, yes, do you want to say something? So we wrap up this panel. Thank you very much for your attention.